Gene, I'm going to grab my headphones.
Okay.
Sorry.
So, hello everybody. Thank you for joining us here for this segment. We are now live. I have the MCLE poll banner posted at the bottom. Renee likes me to enter whenever we do a CLE portion with that showing so that you can do the poll that she is going to put up here presently, so that we can get you to tell us that you are present and accounted for right off the bat. What will happen is this is going to be the way that we are going to verify that you are here with us during the CLE presentation. If you want CLE, please take the poll and please answer yes that you want CLE for this segment. There will be several polls during the course of this panel discussion. Each of the polls will have this banner at the bottom when they are active, and you will see a gong come up when the poll banner appears. So please take those polls, and then at the end of this, there will be a survey. For those of you who want CLE credit, the survey is mandatory, so please take the survey. We always like to hear from everybody what you thought of the panel and give us ideas on future panels, whether you want CLE credit or not. But if you want CLE credit, the survey at the end is mandatory. So what we have now is another discussion on Alice. This brings three litigators, Meredith, who joined us on the last panel, and I didn't really properly introduce. I'm terrible at this, which is why I'm going to allow David to really do the introductions, and maybe we should let the panelists do more formal introductions, because I know everybody, and I just assume everybody knows everybody. But Meredith Addy is joining us with this panel again, and she was a former law clerk for Judge Michelle, and she is a litigator, co-founder of Addy Hart, and she's been identified as one of the top women in IP by, I think it was Managing Intellectual Property magazine, and we're happy to have her with us. She's appealed over 40 cases to the Federal Circuit, and she's one of the few people that's actually had success appealing a 101 issue. Also joining us here today to moderate this is David Henry, and David is co-chair of the program. You saw him earlier today and during the opening statement. He is a litigator. He is a partner at Gray Reed, and he is the chair of their IP department, and he litigates all over Texas and, of course, all over the country, as IP litigators always do. And then also joining us is Frank Angelari, and Frank is a partner and president of Brooks Cushman up in Auto Country, just outside of Detroit. And Frank has a wide range of IP expertise. He does some stuff at the PTAB, anything litigation related, and of course a lot in the auto sector, which today means not just automobiles, but it means computers, it means standard essential patents, which his firm is quite involved in. So we're happy to have Frank join us here today for this discussion about 101 and Alice and Mayo and the chaos from the litigator's perspective. We heard about the chaos, David, from the judge's perspective. I'm anxious to hear what you guys have in store for us. So what I will do is I will recede into the background and let you take it from here. So thank you.
Thank you, Gene. And Frank and Meredith, do either of you have anything you want to elaborate on your roles and your activities? I always like to start with that, just so the audience knows from whom they're hearing.
For me, I think Gene did a fine job summarizing it, and like all of us, we got a broad range of experience in a lot of different spaces. So I think he did a great job. Thank you, though.
I will echo that. Thank you, Gene.
Very good. Well, one of the things that's pertinent to our discussion today, well, maybe marginally, is one of the other hats I wear is I teach patent law and patent litigation at Baylor Law School. And why do I mention that? Because today's discussion about the chaos surrounding patent eligibility is something that I have to try to explain to law students each and every class. And so I, not only from a litigator standpoint, but from an educator standpoint, I would love to have clarity in telling students we can trust the legal system to give us predictability and clarity. And I'm sure at the end of this panel, we're going to provide just that to the audience, right?
No problem.
Perhaps not.
In 2 lines.
Yes, exactly. Exactly. Well, I realize, and one of the things that I've learned from Gene is that people do tune in and out of different sections of this program. So I will tell the audience, if you just saw the remarkable session involving Judge Michelle, some of what we say may overlap just a bit. And for that, we apologize. But those perhaps newcomers, we're going to do a little bit about sort of what got us here. What's the background of eligibility? So let's just look back in history just a little bit. Patent eligibility has, I guess, always had its fuzzy boundaries, but in terms of carving away at what other than everything under the sun, which was a clause that some have heard say, goes all the way back to 1854 in the O'Reilly versus Morse case. In that case, and for those perhaps younger observers in the audience, you may or may not recognize the Morse name or even the phrase telegraph. But basically, this had to do with the transmission of electromagnetic signals for communication, which some of us actually do recall as telegrams, telegraphs, dots and dashes, etc. The invention that was the subject of that case and patent was deemed to be not patent eligible as a, quote, law of nature. And then we jump forward to 1972 in the Gottschalk versus Benson case. And here we had a patent that basically was about processing data by a computer program. That was found to be a phrase that we hear all too commonly today, an abstract idea. But we still had what I think most litigators and judges would say was a manageable landscape of eligibility. Well, then we skip forward to, let's say, 2012, where we have the Mayo case. Now, I don't have this memorized verbatim, so I'm going to read this description of basically the synopsis of the patented technology. The relationships between concentrations of certain metabolites in the blood and the likelihood that a thiopurine drug dosage will prove ineffective or cause harm. Well, that was found patent ineligible, basically as, again, a law of nature. And then the whole world shifted. We got the Alice versus CLS Bank case out of the Supreme Court. And how do I say this politely? All chaos broke loose. What Alice gave us was that abstract, or reaffirmed at the highest level, was abstract ideas are not patentable. Okay, we knew that. But what the Supreme Court gave us as guidance was a supposed two-part test, neither of which I have to confess I've ever been able to figure out. But the more I hear, and especially the address by Judge Michelle just a little while ago, I feel better about not having been able to discern this. First part is the claim directed to a law of nature, physical phenomena, or abstract idea. Now, from the very beginning and to this very day, I still don't really know what directed to means, but I gather from different discussions that that the claim includes an element that is a law of nature, et cetera, et cetera. Well, then we move, if there is the presence of a law of nature, et cetera, one of the judicial exceptions, we move to the second part of the test. And there we are to determine, the court is to determine whether there's an inventive concept. And Judge Michelle just moments ago said he still doesn't know what that is. So I feel much better in not myself knowing what that is. But the Supreme Court gives us guidance. What we're supposed to do, and I say we, the courts and litigants, we're supposed to determine whether there's something significantly more than that law of nature or physical phenomena or abstract idea. And there you have the test. Now, I'm sure everybody can go home and apply this test right now. Mimi, you had a comment.
How did you know? I just wanted to comment about how could you know what an inventive concept is? Because it is indeed an inventive concept that has yet to have been on this earth before it was invented. So I think it's very hard to know what an inventive concept is.
well, that I couldn't agree more. Frank, do you have anything to add on that one?
Just likewise, the directed to is what does that even mean? When is it all part? Is it an element? Is it everything? If it's just one element, there's usually some law of nature lurking inside most scientific advances. That's because they're based on science. So that's another nebulous one. It's tough to manage.
And one of the things I tell my law students constantly as I give them, quote, war stories, is that this is not an abstract possibility. This is not just something that might happen to you. And the same is true here. I think everybody on this panel has actually experienced, perhaps if you're on the patentee side, going down in flames for under this very scenario. Oh, your client's invention doesn't have significantly more. What do you do with that? And then, as we're going to discuss later in the panel, once you get to the appellate level, not going to get a lot of help, are you?
And I think if you wrap this, what you have just said, up a little bit, and you say, okay, what is an inventive concept? What is directed to? And what is significantly more? Are any of those legal questions? I'm asking all the lawyers.
Yeah, I would think certainly not. At least the significantly more are the what's significantly more? What's unconventional? And we're going to get into that certainly in a little bit about the under Berkheimer that we'll talk about a bit. So that's a good preview of something yet to come. Frank, do you want to elaborate a bit on what the CAFC has done with this fantastic guidance? I'm going to get hate mail from the Supreme Court, I guess, but I can't help it. That decision I just think was terrible. But what has the CAFC done with it? Were they smarter than any of us? Well, they are.
Well, one thing they have done along the way is ask essentially for more guidance. There have been a number of opinions that either implicitly or explicitly ask the Supreme Court to sort of help out. The Ariosa case comes to mind, but to try to put a little bit of there are some areas where the Federal Circuit has certainly tried to work within the Alice framework, and two that come to mind most readily is at a lot of these things come out of the software space, and there was this tendency to think, well, my gosh, anything with software and it's going to be invalid. But they were able to at least attempt to kind of carve out inventions on one hand that are either just software or a computer implementing something, versus on the other hand, a genuine enhancement in the way software works or a genuine enhancement in the way computers work. And I think that was actually a significant positive development that the Federal Circuit gave us. And the Enfish case from 2016 is one example of that. Another significant evolution, I think, is this something that you both mentioned, which is the question of fact questions, because many of these issues came up on 12b6 motions, and of course, they can't have fact issues there. But in the Berkheimer and Atrix cases in 2018, the Federal Circuit at least opened the door to the idea that fact questions can exist. Now, how much impact that's had, I think we're going to talk about that a little bit later. Mm-hmm. But at the very least, the idea of fact questions is in play, and it may be more in play in certain areas than others. The last kind of big, I don't know if it's an evolution or not. Actually, the judges disagree on this, but it certainly created a lot of controversy. The American Axle case created a lot of buzz and discussion on the idea that it is an evolution because it's going to a mechanical device, a prop shaft, and historically we all thought those kinds of things were exempt from this analysis. The majority and concurring opinions have stated fairly forcefully that this is not any kind of game-changing event. It's just one case by case. The dissents argue that it was game-changing, and perhaps that was in an effort to encourage the Supreme Court for clarification. Certainly, they were trying to go en banc, and they ended up being 6-6. But that's another significant change. The first two, I think, are more defined and real. This one, we're not quite so sure exactly where it's going to go. Is it going to be a real game changer or not? So those, I think, are three big developments from the Federal Circuit in trying to manage Alice.
Sure. Now, Meredith, once we have cases like Enfish and American Axle, for example, how would you describe the consistency of following those precedents as a court? And just, I know you have some pretty prevalent opinions about the American Axle case and otherwise. So, tell us about your view of the environment of the treatment of patentees at the CAFC level.
I do, and I think we'll get into some of this a little later, but if you could follow cases like Berkheimer, and I think Berkheimer is a very well done case, and I think a lot of us expected to see a shift in federal circuit practice into something that was more predictable based on Berkheimer. But looking at something such as American Axle, for example, you realize that really hasn't happened. But even American Axle aside, I still go up to the federal circuit on a case that was dismissed on 12B, and they say there are no facts here, although you look at the complaint and there are facts pled in the complaint specifically. I'm going to start saying paragraph 24, fact, here's the fact, and quote the patent. But you still go up on appeal and they affirm and they say there's no underlying facts. And so I think there's a problem. I think there's a problem with some kind words in Berkheimer, and I think I have that in front of me. So Berkheimer, while I think the holding is fantastic, I think it really set out what's going on here, and I think if we could follow Berkheimer, we could have a nice development of precedent. But I think also catering to past precedent, which Berkheimer had to do, at least in the panel decision, Berkheimer had to do. It says, as our cases demonstrate, not every 101 determination contains genuine disputes over underlying fact material to the 101 inquiry. And I feel like that leaves open the opportunity for district court judges to rely on all the other plethora of precedent that doesn't rely on underlying facts. So with that in mind, I think you asked specifically about American Axle, which really doesn't fit into this line of is there a fact or not, because American Axle, of course, was dealing with a J-Mall. And so in American Axle, the district court decided or denied a J-Mall that the defendants had requested that the patent was ineligible. And so the case goes up on appeal. And I honestly, if I had looked at that case, I would have said, easy, that's getting affirmed. However, the first thing I usually do when I look at a case going up on appeal is I look at the claims, right? What are the claims? Do we have anything to work with? Or, did the claims just claim, something amorphous in the clouds? And you look at American Axle, and I'm sure a lot of our listeners are familiar with the claims as well. It's a method for providing a shaft assembly for a driveline system. And it gives more details in the preamble about that shaft assembly for a driveline system. It's adapted to transmit torque. It includes driveline components. It has multiple driveline components. And then it goes on to the limitations. And the limitations are very structural for a method claim, providing a hollow shaft member, turning a mass and a stiffness of at least one liner. You get where I'm going here. These are very structural claims. And yet, and there's no recitation of an algorithm. And so I do not see how we get to this is patent ineligible. And to kind of update the procedural posture, the case came into the federal circuit. The federal circuit reversed the decision denying J-Mall and said, not only is this not patent eligible, but it can tell without dealing with underlying facts because it had to do it that way in order to be able to do it on appeal. because it couldn't go back and say, okay, all the facts that were found in the prior jury, case that went to trial were not appropriate. So how did it do that? I honestly don't understand.
No, the last I heard, my car or truck, since I'm in Texas, of course I have a truck, couldn't be propelled by an abstract idea. But
well, that's the new clean energy. We're getting there.
oh, there you go. There you go. No, it utterly baffles. Now, I believe in one of our pre-planning sessions, you also mentioned Chamberlain case that you had some thoughts on.
Yeah, and if we talk a little bit more about American Axle,
Sure.
we can get into what they did and how did they get there. And I think what we're seeing a lot of here, and Chamberlain does this as well, is in order to get to ineligibility, we're seeing a merger of 101 and other statutory sections. So the other statutory sections are infecting the 101 analysis, and that's even more disturbing, right? Because the other statutory sections involve factual determinations as well.
Absolutely.
Some of them involve the specification. And so it really does get disturbing when you see this happening. And so, for example, in American Axle, I think they did this. They said that the claim doesn't explain how to do it. And, well, it doesn't have to. One of ordinary skill in the art can look at the claim and look at the spec. That's a 112 problem.
Exactly.
So I really am disturbed when we start, getting into 112 at a 101 analysis, which is supposed to be a high-level gatekeeper. Mm-hmm. So turning to Chamberlain, Chamberlain was a garage door case. And I don't know if most of the listeners are familiar, but Chamberlain's a big garage door company, and they're litigious, and they protect their patent rights, and they really, really do a good job of protecting their rights. So here in the Chamberlain case, it had to do with a wireless garage door system, which I'm sure we're all familiar with. But in the Chamberlain case, the wireless communications included certain status communications. And so there was something more here than just wireless communications. But in any event, here the court said, well, here you've got wireless communications and you've got a garage door, so that must be not patent eligible. Everybody knows how to do that. And I really think I think they imbued a 103 type of analysis into this 101 analysis. And they also broadened what the improvement was. So in Chamberlain, the improvement was seeing this wireless status information in a garage door opener system. And the court, when it looked at it, it said, oh, the improvements sending wireless information. Well, we've held that that's well known. And so therefore, this is not patent eligible. Very disturbing language in Chamberlain. So I guess to summarize, American Axle, they went in with a 112 type analysis to hold 101 not patent eligible. And then in Chamberlain, they went in with a 103 type analysis to hold 101 not patent eligible. Both of them really disturb me.
Well, in the latter case, seemingly ignoring the idea that the old saying, the building blocks can be old, is the combination that counts.
Absolutely. And that again is a 103 analysis. And that leads me to another realization that I came to as after talking with Judge Michelle on the prior segment, and then with our planning segments, I started thinking, holy cow, we've got two problems in the federal circuit right now. I think two big problems that we would love to see more predictable subject matter or more predictable precedent. One is obviousness and one is eligibility. So you look at obviousness, and almost every case they say, well, this is a question of law. This is a question of fact. It's a question of law with underlying facts, but really obviousness is a question of fact. In the lower court or the PTAB, they found all these facts. Well, that's substantial evidence, end of story. And they don't even look to see those are really facts that support the decision. Is it substantial evidence that supports the decision, or is it just a whole bunch of evidence? And nobody looks at the legal question here. That's obviousness. But now look at 101. On 101, they're saying, this is a legal determination and we could do whatever we want and we're not going to look at the underlying facts. And I just thought that the dichotomy of those two were pretty interesting.
Oh, absolutely. And, if you're going to say, as in Berkheimer, that there can be facts there, the way it's being treated, you almost have to have a posita type analysis as part of that. And
Absolutely.
Where are you going to get that in at a 12B level, which, as we're going to talk about in a minute, is where these things often come up. And then, of course, if you're one of the victims of a Rule 36 affirmance, like I have been, you don't really understand, okay, what was the court really thinking? What was the panel thinking?
One thing that I think is worth mentioning is the two issues that seem to get swept into 101, enablement and obviousness. You can see, if you look at the Supreme Court's test, you can see why that happens. Because, of course, we talked, David, when you went through the test, one of the prongs looks for an inventive concept, and of course, obviousness is the current Patent Act's bar for invention. So it's not surprising that if something is obvious or not, obvious, not inventive, now you're basically running a 103 analysis on 101, which is, of course, it's not surprising that we're going to get some confusion. And then on the enablement side, the Mayo case talked a lot about preemption and the breadth of claims, and I think Judge Dyke seems to cite that in some of his opinions, and it's a focus of his, and I would guess it's because of Mayo. But that's the kind of thing that's going to almost naturally trigger an enablement kind of thought process, where if you're claiming something very broadly, then it leads to this idea, well, you're not really telling anybody how to do this, you're just claiming this idea. And so this interrelationship between preemption or breadth, and breadth suggesting not enabled or ineligible. And I think that's, of course, one of the reasons that so many, of course, there have been so many petitions filed in the Supreme Court, but also why Federal Circuit has seemingly been asking for further guidance. Just as
you mentioned a topic that really wasn't on our list of things to talk about today, but it was preemption. I read Alice as basically saying preemption is the issue. Really, at the end of the day, that's the issue. And I know that I had a case where, I argued that since preemption is the issue, I gave a number of examples of how of real world applications that would not be precluded by even the broadest interpretation of our claim. Now, it didn't work at the time, but I'm just curious, and it was early in the Alice chaos. What do each of you think of that approach? I mean, for practitioners, going back to this issue of preemption kind of is, at the end of the day, the issue. Court, here are however many things that would not be preempted, not be covered by this claim. What do you think about that approach?
I think that you're giving one example of. I think we as advocates have, you can call it an opportunity or burden. There's lots of, because there are so many different, and of course Axel's classic case, because you have so many different opinions expressing different views of how this analysis should happen or it opens up opportunities for taking creative arguments, different arguments. You're not sort of locked into a certain range of arguments. You can argue preemption. You can argue that it is enabled. You can argue that it's tangible. So you've got a lot of avenues, but then you're sort of running into, well, what panel am I going to get? And so you don't necessarily know. Of course, you don't know, but at least you have options. And so I think it makes sense to look at these different ways of presenting this issue, because that it's amorphous, and so you take advantage of that and pick the route that's best for your case. Well,
while we're on that topic, why don't we explore that a little bit? Meredith, any other sort of broad brush? Well, you might try it this way. You're representing a patentee. You might try this approach. Let's just throw some out there for the audience.
I was going to mention I went the preemption route too about 2 years ago with a client, and the client was a very savvy client. The client wanted to do this, and he worked with me on it, and it was I thought a really excellent example of why there cannot be a 101 in problem because we don't preempt. And yet we had the same problem, but we went into the oral argument. We got our panel. You reminded me of this. There were 3 panels on the day, as there usually are. And one panel, we looked at the court, those judges, we thought we'd win on that panel. Mm-hmm. The other one, we're like, yeah, that one, we're not so sure. But the panel we got, we knew it was going to be downhill. And, I wondered as I stood there and got hammered about stuff that didn't matter. I wondered, why did I even argue this? I should have just stood up and said, I know you guys, I got it. I know what you're going to say. And that was
now, come on, Meredith. We all hold out hope no matter what. When we're standing up there, we believe we can persuade anybody, and because we're confident we've argued, we've developed these issues and we believe in them. And
that's true. We got up there, we were ready to go, but it didn't take that long to realize that we weren't going to talk about the merits of this at all. We were going to talk about just side issues that didn't matter at all. And so I knew that was, and actually it was a very active panel talking about stuff that wouldn't change the decision. So I knew where it was going.
In that particular case I mentioned earlier, I got hammered on enablement, by the way, and then got a Rule 36. So who knows? Any other approaches? I mean, other than arguing, preemption, just a strategic choices that come to mind. It's a generic issue.
Well, again, Axel, it's the nothing more test. Is it a test or is it not a test? Of course, the majority is adamant it's not a test. The concurrence says it's not a test. The dissent say it is a test. But of course, they didn't go en banc, so I guess it's not a test. But again, you obviously in some cases, as an advocate, you're going to be arguing it is nothing more, and you can cite American Axle. And in another case, on the other side, you can say it's not a test. And so that's one. I think the American Axle concurrence emphasized that this is a case-by-case decision. So that might be something that, an avenue that you're going to want to take. And I think the final thing is anybody with a mechanical invention is still going to push hard that, hey, this is a mechanical invention that happens to employ laws of physics. It's not reduced to the laws of physics.
It interests me that, they do say, this is just this case. This is case-by-case development. And yet, it's very convenient to come in and say, as we have held in our previous cases, remember this case about Bluetooth? Remember this case about Wi-Fi? Remember this? And to me, that bothers me because a patent in and of itself is defined based on the 4 corners of the patent. And so I don't think it's appropriate to go in and say, we have held that, the addition of wireless is not patent eligible, because you're looking outside of the 4 corners of the patent, and I don't think that's appropriate, but they do that a lot.
Now, I haven't done this yet, but I've been pondering the impact of the de facto merger in many cases of obviousness in 101. And I've thought about possibly getting some sort of a declaration from somebody I would purport to be a posita and attaching it to a complaint. What do you think about that?
The more that you go ahead.
Yeah, but no, I suppose it in one level it wouldn't hurt. In theory, you should be able to attach that later, I guess. And it's ironic that even though your patent is presumed valid, as an advocate, you feel like you need to do that. That in some respects is a red flag of something potentially being amiss. If we're representing the patent owner, we shouldn't have to prove anything. Right. But it's fascinating that you sort of feel compelled, or not, maybe not compelled is too strong, but some need for that based on the state of affairs.
Yeah. Well, I think we can all agree something is amiss, and perhaps we can. That sort of leads us to the next topic that we talked about, and that is the Supreme Court. Is the Supreme Court going to help clean up this mess, Frank?
I'm hopeful they'll take American Axle, but whatever I saw a statistic, they denied some crazy number of cert petitions. I don't know, it's 60 or something. I can't quote it, but it's a lot. And they didn't take Ariosa, even though you had, I think, 3 or 4 different concurring and dissenting opinions, basically begging them, saying this is a phenomenal invention. It gets rid of an invasive procedure for pregnant women. So it's a huge health advantage. It's meritorious, but we got invalidated because of Mayo. And so something's amiss here, but nothing. There's not a lot to talk about the Supreme Court.
Oh, I'm sorry. Go ahead. I'm
just going to say there's really not much to say because they're not saying anything, and I guess we can infer from that they don't want to say anything, at least right now. But I'm hopeful they will take American Axle.
Now, I'm not recalling off the top of my head, but it seems like there have been at least a couple of opinions out of the CAFC that, in essence, begged, as has been described, begged for guidance. Can anyone off the top of their head recall which cases those were? I can't at the moment.
Just this one, and just American Axle and Athena, I think, are the specific ones.
Yeah.
Where the court has been divided, and there's been, an attempted en banc, and you have several varying opinions. The other time I remember doesn't have to do with 101. I think it was, I want to say it was Bilski, or I think it was Bilski. No, and maybe because I remember there was I believe a Judge Michel opinion and a Judge Rader opinion, and they were on either side. So it's happened before with other doctrines, and they've taken it, but it hasn't really interested them here. And there's I think maybe a couple of issues here. It'd be interesting to see if they take American Axle, because to me that is not software, and I don't know what the answer is for diagnostic inventions. I don't know why they're not interested in those. But for software, I don't think they understand what software is. I think they think it should be copyrightable. It's like a book. It's code. I don't think they understand it as something that performs a function. And so I would worry if American Axle was a software case, because I just would worry that we'd be in a world more trouble. But at least with American Axle, maybe they'll see, well, we certainly didn't mean this.
Mm-hmm. I guess if it were software, we could end up with almost an in-fish kind of a result, perhaps. But
or a reversal of an end-to-fish kind of result,
exactly.
Which would scare me to death. Well, and they've done so much damage to software cases already.
Absolutely. Well, that's true. That could make it even worse. Well, we've talked sort of generally about the chaos at the CAFC and otherwise. Maybe I think you've done some research on actual statistics. Is that correct?
That is, and honestly, I have to finalize my updating of them. So hopefully, I'll get an article out to IPWatchdog in the near future with these. So you're not going to get any cold hard facts, but in general, if you look back to the beginning after Alice, we all know what we saw was Rule 36 after Rule 36 after Rule 36, and I had them all. And it's very hard to track which Rule 36s are 101 because it doesn't say. So what you have to do is you have to pull the Rule 36 down and then go back and look at the briefing for every single one to track the Rule 36.
Sure.
And it was insane how many Rule 36s there were. And I won't give you the numbers, but as you know, we were looking at something like a 97% affirmance of patent ineligibility. Yeah. So that's gone down. It's a little better. But we're still seeing, I think, around the, low 90s of affirmance of patent eligibility. And the shift we've seen, however, is instead of seeing all these Rule 36 decisions, because as most of you know, the court did get criticized. There were a couple petitions for cert to the Supreme Court saying Rule 36 should never happen, which of course the Supreme Court ignored. But the Federal Circuit seems to have shifted to another type of decision. The Federal Circuit can issue a lot of different types of decisions. The type of decision that we all read and refer to as a precedential decision. And in the court system itself, that takes longer to get out. So you have to, the court, first the panel gets the decision written, and then the panel sends it out to the rest of the court for review. And the rest of the court can comment on it, and they have a certain amount of time to review it and say, trying to make sure it's in accord with precedent. A non-precedential decision, which we see a lot of, in fact, I would say the majority of the decisions we see from the Federal Circuit are non-precedential now. They don't have to go through all the checks and balances that a precedential decision does, so they get out faster. And, I think the court is thinking, well, this is really good for the litigants because, there's no real question here and they need a resolution and we're getting it out to them. And I don't disagree with that. And then you see a couple other types of decisions, one of which is Rule 36. So in looking at these 101 cases, what I have seen is a distinct shift from almost anything being a Rule 36 to we're still affirming almost every determination of patent ineligibility, but the Federal Circuit seems to be writing 8 to 10 page non-precedential decisions in which maybe 5 or 6 of those pages is background. So they're not very deep. They just get the job done. And I think, they believe, well, we're giving the parties a resolution. We're telling them our thought process, and that's better than Rule 36. So that would be the biggest change I'm seeing. But I really haven't seen a lot of changes to the amount of cases that go up as patent ineligible that are getting reversed. It's still, if it's not 90, it's very close to 90%.
Goodness. So I guess the lesson there is you better try to prevail as a patentee at the district court level. But with that, Frank, let's talk a little further in the trenches. What's happening at the district courts? And you've also done some research into actual data and trends. What are you finding?
So when we were talking about this in the past week or so, one of the things I think that came up was whether Berkheimer and Atrix changed the process a little bit by opening up this door for fact questions. And so I did some searches on Docket Navigator for cases that raise a 101 issue, and I expected to find fewer 12b6 motions because of Berkheimer and Atrix. And when I looked at 2 time periods, one is 2016 and 2017.
Frank, can I interrupt you just for those in the audience who may not be familiar with Berkheimer? Would you just give a little snapshot there? Thanks.
Sure. Berkheimer and Atrix are 2 cases that came out in early 2018 that more or less opened the door to the idea that there could be fact questions in 101. One example is when you're looking at the step 2 part of the Alice test, and you're making an argument that something is well known. There could easily be a fact dispute on whether something's well known. Mm-hmm. So those, and I apologize for jumping in, but those 2 cases, it seemed like would trigger maybe a slowing down in the likelihood of success on 101. Because now you have a fact question. Well, because most of them were decided early, and now you're injecting a fact question. So at the very least, you'd push it to trial. But when I did some searches on Docket Navigator, I was actually surprised to find that as a percentage of sort of when 101 issues are resolved, the 12b6 actually went up. So again, the 2 time periods I picked were 2016 and 2017 on one hand, and then 2018 to date on the other hand. 2018 well, I was surprised too. I didn't believe it, so I ran it again. But 2018 to date is technically longer in time, but we had COVID in there, so I kind of surmised that it's sort of close enough for a comparison. And the number of sort of hits totally went down from 1,042 to 945, so you had fewer decisions, so to speak. But the number that were on 12B6 went up from 439 to 523. So you had 100 down on the total and 100 up on 12B6. From a percentage perspective, you went from 42% of them being decided on 12B6 in the first period, the pre-Berkheimer period, to 55%. That was very shocking to me. The other thing that I just did a little bit of looking around at some of the more popular districts. Interestingly, the Berkheimer effect, if we're going to label it as such, may have had more effect in some districts than others. So, for example, the success rate for somebody asserting invalidity under 101, it actually went slightly up in Delaware and Northern District of California. Went from 56% to 62%, again from 2016 to 17 period initially to the 18. So it went up slightly in Delaware and in Northern District of California, but actually in Eastern District of Texas and Western District of Texas, it went down, not hugely. Eastern District of Texas went from 62% to 49%. West Texas went down more, but they had a relatively smaller sample size. So I guess the takeaways are, for me anyway, procedurally we kind of are where we always were. Maybe the shift to 12B6 is because people are being more selective when they raise it. Like if I've got a clear, no fact question, I'll raise it. If I don't, I'll just wait. I don't know. But and then again, the likelihood of success seems to vary somewhat. I should say the impact of Berkheimer on the likelihood of success seems to vary a little bit by district. And these are from these are docket navigator numbers. But like you, Mimi, I didn't go back and drill down on every case, of course. So these are kind of macro trends. There could be some issues in the data that's imperfect, but I think from the standpoint of just macro numbers, it's interesting.
So for people in the audience who are maybe scratching their heads, yes, we really did say that the case law is that 101 can involve fact issues, and yet patents are being poured out at the 12B level, increasingly in some districts, but at least fortunately for patent holders, a little less in others. Mimi, what do you have to add to that?
One more round of statistics. When I did my research back in 2019, looking at what was this doing to the patentee assertion in general, and what I found was, of all the cases of the district courts that were decided on a Rule 12, and I think I may have done 56 too at the time, of all these cases, how many of them are getting appealed? How many of them are actually getting to the federal circuit so that then they can be Rule 36 or have a non-precedential opinion? And I found less than 40% were getting there. And so there's this huge, I think, squelching of IP at the 12B level, right? Because a patent is, how can you hold a patent invalid on a motion to dismiss on the pleadings? That's a procedural motion that doesn't deal with the technology at all. So, but we are, and that's the way we do it. And then there's this lack of appeals. And if you think about it, from a patentee's perspective, once you know the stats going up to the federal circuit,
right,
it doesn't make sense to spend another several $100,000 appealing for what you're likely going to get. So I went back and I did some research for a more recent time period, which I need to confirm, but I would have, I actually didn't expect it to get any better, because I think more people understand this now. And I think it's, and it isn't, it's going to hover probably around 40% or a little less again. Once they get dismissed, once they get held invalid, it's not worth going up to the federal circuit. So I guess the federal circuit can be happy. It's got a little smaller docket.
Goodness. Well, for patent holders out there, this has been a rather depressing discussion, but nevertheless, we still have patent litigation. We're going to have patent litigation. Some of the discussions of that you had with Judge Michelle would indicate some patent litigation trends are up. I guess close to what I'd say would be a closing thought, unless there are others, and we can talk. We have a few more minutes. What is a patent holder? What is counsel for a patent holder to do? You know, you're thinking about everything we've talked about, the dire chaos at the upper courts, and the sporadic application of eligibility at the district court level, the statistics on 12B, the statistics at the CAFC. What is a patent holder to do? That's the ultimate open-ended question, but thoughts?
I think the reality is that there's more selectivity going on because, you know, so I gave some district court data. Mimi gave some sort of, you know, obviously the federal circuit data is not great. I think we're seeing greater selectivity in terms of filing cases, and I don't know if there's any way how that's going to change. I think that the difference opinion, I mentioned this earlier, but the differences in opinions of the various judges and the different arguments that have been sort of laid out there give you more opportunities to argue, you know, something that's conducive to your patent. But you still have, if you lose, you still have the problem that Meredith raised, which is the, you know, this is it going to change? I'll just give you one interesting point that I sort of realized when I was looking at the split in American Axle. American Axle was 6-6, and obviously all those judges believe strongly in what they believe. I'm not criticizing any of their views, but Judge Wallach was one of the 6 who voted not for en banc, and she's retired, and I believe Tiffany Cunningham has been nominated. I don't know that she's been confirmed. Has she been confirmed? Yeah, so
I don't think so.
So I don't know what she thinks either. And of course, Judge Moore just became chief. So it is at least possible that the views on en banc could change, and then we might get some more guidance. You know, if the federal circuit does go en banc, and so that's at least, if the Supreme Court doesn't take it, it's at least possible that the federal circuit could do something. You know, maybe not tomorrow, but sometime in the future.
Right. Me?
I think there's some hope here. The selectivity is certainly a factor, but I think the quality of patents that are coming out of the patent office now is higher. And, you know, I have several clients who started with a patent that was pre-Alice, and they've had something pending, and they're able to go in and adjust. And so I have have a couple cases where we're going to go back in post-Alice now and deal with these patents that that the prosecutors have been doing a really good job of shoring up. Not to mention, you know, you've got the newly filed patents that the savvy prosecutors are able to deal with this Alice issue. And of course, I thought the PTO guidance is terrific, even though, you know, the federal circuit may not like it, it's still very good. So while I end up getting a lot of these cases on appeal, and I have to be honest with my clients, you know, the outlook isn't great. I've noticed I do something a little different with these cases than I had usually do. I usually review a case and I say, okay, based on my understanding of the law, are we going to win? You know, is this winnable? And that's, but now I find I look at 101 cases and I say, okay, based on my understanding of the law, which is all over the place, but including Berkheimer, and taking into consideration that we might get a panel that's favorable and we might get a panel that's not, and also taking into consideration that the court really needs to do something about this, and maybe this is the case. You know, is this the case? Or can we interest the court with this case? So I start to look at it from a little different perspective of, hey, maybe there's something we can do with this case. And that doesn't help the individual litigants so much. But it, you know, it's kind of my, you know, my sunny side of looking at things. I keep thinking we're going to get this resolved, and you know, we got better patents, we got better claims, we've got change on the court. You know, I'd love to see the federal circuit work this out, because honestly, I think they understand the problem better than the Supreme Court or Congress.
Oh, I completely agree. Absolutely. Well, Gene, we're coming up on the last couple of minutes of our time allotment. Do we have any, not that we'll be able to necessarily answer them, but do we have any questions from the audience?
Yeah, we do, and we can go until 1:30 is fine. So let me. There's a couple things while you were talking. One of the things you had mentioned that you asked about when the Federal Circuit had done this cry for help, and one of the cases that immediately popped to my mind was the interval licensing versus AOL case, where Judge Plager had that dissenting in part and concurring in part, and that was from July of 2018. And I thought maybe I'd read the very end of his what was really a very scathing opinion here. Regardless of what other courts may do, an appellate court's job is not only to decide the immediate case before it, but also to rationalize and regularize the law to be applied in future similar cases. Judge Rich believed that words have meaning. Years earlier, Professor Weinstein expressed well the same thought. What can be said at all can be said clearly, and we cannot talk without all must pass over in silence. The limits of my language mean the limits of my world. This emperor clearly has no clothes. We need not wait for our children to tell us this. The legitimate expectations of the innovation community, as well as the basic notions of fairness and due process, compel us to address this 101 conundrum. And that was after he went like 10 or 12 pages of just, let me tell you more about what I really feel. So, 3 years later, nothing has really changed, and it's sad. So I just throw that out there for consumption. If you want to feel good about at least what one of the judges thinks, read that opinion. And then as far as questions go, we do have some questions here. Let me pull up the questions box. A couple of them I thought were really pretty good. One of them was essentially, in a nutshell, if we don't have the Alice test, what would you, as the panel, recommend in place of Alice?
Who wants to take that one?
And maybe while you think, I'll give you a minute to think about that one, because there's another question here that asks about if you were a member of Congress and you could change, you're a member of the Judiciary Committee, and you could reword Section 101 to make it clear, what would you do in order to help this problem? Now, I know you haven't seen those questions, so I'll give you a minute to think about it. I pulled up 101, and I have given this some thought, and I think one of the things that creates a lot of issues is the word new in 101, where it says, whoever invents or discovers any new or useful process. And I think that is where Justice Breyer and others were able to bring in the conventional routine aspects of Mayo, and then really overruled Diamond versus Deere, where they said, newness is about 102 and other parts of the statute. Let the other parts of the statute do their work. So I would take the word new out. Mm-hmm. And then I would also think about having, subpart B, and specifically say, we don't need judicial exceptions. There are no judicial exceptions to patent eligibility. Because they're unnecessary. Really, all the problems that they're trying to get at can be addressed with 102, 103, or 112. So those would be the two things that I would do. So let me kick it back to you guys on the panel and say, if we don't have Alice, what would you like to have? Or maybe what tests would you like to go back to?
Well, if I were Congress, one idea I've had is that much as we had the language in 103, the patentability of an invention shall not be negatived. I believe I'm trying to quote here, by the manner of invention, flash of genius in essence. I think we could have perhaps in 101 that the eligibility for patent protection shall not be negative by the presence as an element a law of nature or something. They just have something that said this does not invalidate in and of itself.
Right.
That's my idea. Mimi, Frank?
I was going to say, and I actually, I'll preface this with, I thought what Gene said was perfect, and I think that maybe it was the Stronger Patents Act, but one of the more recent attempts at legislation, I think some of the proposals were to get rid of these judicial exceptions. Right. I think it's really funny that we need a statute to specifically get rid of the judicial exception that the court created. But before I heard what Gene had to say, I was going to say sarcastically, I don't think they need to do anything because I think they've blown it all out of proportion beyond the words of the statute to begin with. And I would go back to what Judge Rich said, and I can't find the case quick enough. And it's like In re Bass or something like, or Bell. And he said, look, the patent statutory framework is like gates in succession, and the first gate is eligibility, and it's a gate that the key is very easy to open. Is this something that should be patentable, or is this something that is already known, or not already? Is this something that should be patentable? And that's really the all he said. And then I think if I can find that case, I might go back and read it again because it's so good about what just preliminary hurdle this is. Then he goes on to the next step is 102 or 112, and by walking through the statute that way, he shows how the drafters created it and what they intended to happen. And I wish the Supreme Court would go look at that case of his, because I think it makes it all so clear.
Absolutely. And Frank, I'd like to get your thoughts on this too, but let me throw this out there and see if this flies with you all. I've written this a number of times and said it over and over again that I think what we need to do is go back to State Street as the test. I think Judge Rich got it right, but I would modify it a little bit. I think when he said useful, concrete, intangible result, there was one problem, or actually two problems with that. The word use is redundant because we already have that in 101, and it's a different part of the test. It's a utility. So we can take that out. And the result part, that's the unfortunate part. By adding that word, it kind of made it, in the mind of some judges, a black box kind of test, I think. But if you focus on the concrete intangible, then I think everything is solved, right? You're satisfying 112, and if you do that with an eye towards the prior art, you should be fine with respect to 101, 102, 103, and 112. And frankly, when I teach new attorneys and law students how to draft applications, I tell them, read Judge Rich, just like Mimi was saying, and focus on the concrete, intangible description, and you should be okay. So I think Judge Rich sort of had it right, and we've kind of screwed it up since then. Thoughts on that, Frank?
I think I tend to agree with what you folks are saying. Gene, when you asked the question, what I was thinking of is, do I have to have a test? Which I guess is another way of saying, it's like where am I in the supply chain? If I'm Congress, I get to make my own rules. If I'm the Federal Circuit, I'm kind of stuck with the Supreme Court, and I guess the Supreme Court could limit their test. But laws of nature and physical phenomena are prior art, right? So this whole idea of whether it's directed to just an element, or if a claim is directed to just a law of nature, well, it's going to be invalid under 102. And then abstract ideas, I think that's part of the way we get into this enablement idea. So this is all another way of saying what you said. Judge Rich said the other elements of the statute do all the meaningful work that it seems that the Supreme Court is trying to do with this, and maybe with less uncertainty.
Yeah, and what I'll also say is, being inside the Beltway and going to some meetings and talking to people and having some sense of the conversations that are going on that have really never stopped to try and fix 101, even if they're not going on, they haven't been going on Capitol Hill. Interest groups and others have been trying to talk about being ready for when the moment is right. there has always been this underlying concern that, well, by some, that maybe we shouldn't do anything because of what, Mimi kind of just said offhanded, I think, well, is the Supreme Court going to care? Are they don't follow the statute to begin with. So if we change it, are they going to follow it anyway?
Maybe we just get rid of it altogether. And I think that was a proposal.
That's David Kapos suggested that. Yeah.
I like that. Just get rid of it altogether, because then they're forced to look at 112 and 102 and 103, which I feel like the Supreme Court tries to dump everything into 101.
Yeah, the other thing about that really worries me is then I think that we would see that they would be convinced that their judicial exceptions were right and Congress ratified this Supreme Court, and it's not just this court, it's, the various configurations of the modern day, however you want to define it, court just has not been really friendly to patents or business in a large extent, and I know a lot of people disagree with that. They say, well, how could you say that? They bend over backwards for business. Well, they do in some ways, but they go out of their way to make it difficult for, the businesses that create the most jobs in America, which is just, befuddling. But we have another interesting question here. I'm looking at time. We still have time. Going back to the strategy discussion regarding 101 and motions to dismiss, to what extent do you plead or include facts regarding prior art at the time of prosecution? Any risk benefits to this approach? Have you had any successes with that? So I guess what they're trying to get at is, in the complaint itself, do you mention the state of the prior art as it existed at the time of filing, which is supposed to be the pivotal moment, right?
I'm guessing that the thought there is that you would be able to argue that the patent invention is not well known because it's sort of, David, you kind of made this point a little bit about sort of proving the validity of your patent in the complaint. I'm guessing that's the thought process, and I guess it probably doesn't hurt. You'd always be worried about potential admission, I suppose, but you might be saying something that you hadn't thought through or don't realize the ramifications of it. Those are my initial thoughts.
The way I usually do it is to wrap it in, this is the improvement. Every time you talk about the invention, this is the improvement, or that is the improvement, or look, here's another improvement. And by talking about the success or the improvement or the efficiency or the removal of a step or whatever it is that you're doing, you really are distinguishing over the prior art without specifically stating what the prior art or the state of the prior art was.
If you have particularly good examiner reasons for allowance in the file wrapper, you might attach that as an exhibit. I'm just shooting in the dark here, just trying to think of ideas.
Yeah, people are starting to get creative, right? I
thought of attaching the whole file history just because there's got to be facts in there. And that way, when the Rule 12 motion's filed, I have that whole file history and I can just dig through it and say, fact, 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 fact.
Yep. Absolutely.
I haven't done it, but I've thought about it.
Well, so now that's interesting. Let me throw this out there. I hadn't thought about, the preference, I guess you might call it, or the practice for patent attorneys when you're dealing with examiner interviews, for example, is to have, Attorney Quinn spoke with Examiner Smith on claims 10 through 20 regarding prior art A, B, and C. No agreement was reached, period. Agreement was reached on claims 21 through 25, period. That's it. There's nothing. There's nothing about what was actually discussed substantively. Nothing. Should prosecuting attorneys think more about trying to create more facts in the record?
I believe so, strongly.
And I think they are. Honestly, as I mentioned earlier, the attorneys that I'm dealing with that are working with these pre-Alice patents that have now been in the patent office for so long, that's exactly what they're doing.
Yeah. And the way you do that is you go back into reissue, right, Meredith?
or you had something pending all along.
Right.
But either way.
Yeah, you hope that you had that for sure. We have another
Well,
question.
Go
Go ahead,
sorry.
David.
I was just that leads to another comment that's a little ancillary here, but if you don't have, as we have in our group, the rule that pretty much everybody's involved to some degree in prosecution and litigation, so one informs the other. One hint to prosecutors out there, patent prosecution people out there, is talk to patent litigators. Spend some time and get an idea of where the landmines are in this environment, and factor that into your prosecution. Maybe that's obvious, but I find in looking at various files that doesn't appear to be obvious.
No, it's not obvious, but what I will tell you is I will preach what you guys have just been saying about this, because I have been preaching what some litigators have been telling me about, means plus function claims, because, law professors tell the students, oh, don't ever put means plus function claims in your patent, and it's like, that's just terrible advice. I mean, you don't want only means plus function claims, but
Right.
they have a place, right? And they're uncertain, and uncertainty settles litigations, right? And I mean, it's when you have certainty that you can't settle. I mean, and I don't understand why people don't get that. I mean, I guess you don't get that if you've never litigated, right? Because you think, oh, well, it's clear that I'm going to win, so you should settle. No, if it's clear you're going to win, there's no chance it's going to settle, because the only settlement is a capitulation, and nobody capitulates, especially with the federal circuit. I mean, I'm pontificating, I'm getting worked up, because you could go up to the federal circuit and it's a flip of the coin, right? You might as well you've gone that far, just go with the flip of the coin at the federal circuit.
So there are two different kinds of uncertainty. I think that you just pointed out, and there's uncertainty in the technology and in the prosecution and in the scope, and then there's uncertainty in patent doctrine. And I think uncertainty in patent doctrine is a big problem.
Right. Absolutely.
So they're just different.
Yeah, no,
that settles cases too, but not on the good way.
Yeah, no, that was not the uncertainty I was talking about. But that's another program for another day. Or maybe that's the program we've been having. I think, sometimes I wonder whether I'm still sleeping and this is a nightmare and I'm going to, wake up. But my goodness. I'm looking at the clock. I think we're at the point where I need to kick it back to David so we can go around the horn and get your final thoughts. So thank you all. I really appreciate you doing this panel. I'm sorry we didn't get to any more questions, but thank you.
Well, it's certainly been a pleasure. I guess may I ask you any closing thoughts for the audience, things they just have to hear?
I think they've heard enough from me. Thank you.
Frank?
Likewise, I think we had a great session here, and we're good.
We're going to make that unanimous. It's really been interesting. I wish we had been able to give more concrete answers, but to the audience. But at least the perils that lie ahead if you step into this thicket. So thanks everybody for watching. It's been a pleasure.
And thank you, David and Jean, for putting this all together.
Great.
Yes,
Well, thank you, everybody. I really appreciate it. I appreciate the panel. I appreciate you being here. Please remember, if you want CLE credit, to do the survey. The survey is at the bottom of your browser window, a green button. We always appreciate hearing your feedback. Even if you're not looking for CLE, it'll only take you about a minute to do the survey. We get some of our best feedback and our best ideas for future programs from our viewers. So if you could take the survey, we always appreciate hearing from everybody. We're going to take a 15-minute break, and then we're going to come back with Hatch-Waxman and PCIA litigation. Again, we're going to focus on pretrial motions to dismiss practice, what's going on in that area. And we have some attorneys from Coase and O'Connor here to lead us in that conversation. So we'll see you in 15 minutes at 1:45 Eastern.